So may I read the first paragraph of the application is that I have focused, Lordship, I have focused the first para of the letter. First of all, may I read the first para of the letter, subject letter. The Honorable Judges says that we are writing to seek guidance from the Supreme Judicial Council with regard to the duty of a judge to report and respond to actions on part of members of the executives, including operators of the intelligence agencies that seek to interfere with discharge of his/her official functions and qualify as intimidation, as well as the duty of report any such actions that come to his/her attention to relation to colleagues and or members of the courts that the higher courts supervises. This was the first paragraph of the letter. In this regard, my humble submission is that through this paragraph, the Honorable Judges seeks guidance from Supreme Judicial Council with regard to duty of a judge to respect and respond to actions on the part of members of the executives, including operatives of intelligence agencies. Therefore, my humble submission is that this segment of the letter may be referred to the Supreme Judicial Council in order to provide guidance, and some appropriate amendments or insertions may be made to the Code of Conduct for Judges regarding their interactions with executives in such circumstances. Now, my Lord, paragraph 6 of the letter is most important. The paragraph 6 of the letter addresses allegations of interference in the judicial work of judges, harassment and exertion of pressure. It recounts an incident involving the abduction of the brother-in-law of a judge of Islamabad High Court by individuals claiming officials with the ISI. Additionally, a complaint was lodged by an additional district and session judge who reported threats and the throwing of crackers into his residence. Furthermore, it was alleged that during routine maintenance, hidden cameras with SIM cards were discovered in the official residence of an Islamabad High Court judge, capturing audio and video recordings. The USPs retrieved from these cameras contained private recording of the judge and their family, constituting rather serious accusation. This is very serious. These are the very serious allegations leveled by the Honorable Judges. These allegations fall within the scope of criminal offenses. According to principles of criminal laws, providing the date, time, place, and manner of the offense is basic requirement to establish an offense. However, the aforementioned accusation lacks specific details such as names, individuals involved, CCTV footage of the court premises and outskirts of the residence of the judges, or any other tangible evidence. Therefore, my humble submission is that in order to thoroughly investigate these allegations and to fix responsibility to the delinquents for arriving at just and proper conclusion of the matter, the Pakistan Bar Council proposes the formation of a judicial commission may be comprised of one or more sitting judges. As such, factual controversy cannot be inquired, investigated under Article 184(3) of the Constitution. This commission may be allocated a specific time frame to conduct a thorough inquiry, and a consequence whereof the delinquent whosoever may be prosecuted under the criminal law. Nevertheless, judges of the Honorable High Courts and subordinate courts possesses the authority to prosecute any individuals who interferes with the judicial work under Section 2 of Pakistan Penal Code and Contempt of Court Act 2012. It is imperative to establish a precedent for prosecuting such individuals to serve as a deterrent within society and uphold the sanctity of the judicial process. In this regard, the judges throughout the country may be encouraged to exercise bold is such powers of the laws available to them. So in this regard, if I may be allowed, may I read the section 228 Pakistan Penal Code, which is very much clear, Lordship. Lordship, intentional insult or interruption to a public servant sitting in judicial proceeding. Whoever intentionally offers any insult or causes any interruption to any public servant while such public servant is sitting at any stage of a judicial proceeding shall be punished with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 3,000 rupees, or with both. The procedure for this section has been provided in section 480 and 482 CRPC. So, with the permission of this Honorable Court, may I read these sections 480 and 482 CRPC. May I read, Lordship? Section 480 CRPC. Procedure in certain cases of contempt, when any such offense as is described in section 175, section 178, section 179, section 180, or section 228 of the Pakistan Penal Code is committed in the view or presence of any civil, criminal, or revenue court, the court may cause the offender to be detained in custody, and at any time before the rising of the court on the same day may, if it thinks fit, take cognizance of the offense and sentence the offender to fine not exceeding 200 rupees, and in default of payment to simple imprisonment for a term which may extend to 1 month unless such fine be sooner paid. Now may I read, Lordship, the section 482 CRPC. Procedure: the court considers that case should not be dealt with under section 480. The court in any case considers that a person accused of any of the offenses referred to in section 480 and committed in its view or presence should be imprisoned otherwise than in default of payment of fine, or that a fine exceeding 200 rupees should be imposed upon him, or such court is for any other reason of opinion that the case should not be disposed of under section 480, such court, after recording the facts constituting the offense and the statement of the accused as hereinbefore provided, may forward the case to a magistrate having jurisdiction to try the same, and may require security to be given for appearance of such accused persons before the such magistrate, or if sufficient security is not given, shall forward such person in custody to magistrate. Number 2, the magistrate to whom any case is forwarded under this section shall proceed to hear the complaint against the accused person in manner hereinbefore provided by the law. Now, another law, my Lord, which is Contempt Act 2012, is also provided the punishment for the, if I may be allowed, may I read the Contempt of Court Act 2000. जी. Lordship, Section 3 of the Contempt of Court Act 2012. Contempt of court definition.
Contempt of court ordinance 2003 which is invalid law उससे पढ़े नहीं ये strike down हो गया था बाद में क्या करना है
definition छोड़े operative part बताएं.
Lordship, whoever disobeys or disregards any order, directions or process of a court which he is legally bound to obey or commits a willful breach of a valid undertaking given to a court or does anything which is intended to or intends to bring the authority of a court or the administration of law into disrespect or disrepute or to interfere with or obstruct or interrupt the process of law or the due course of any judicial proceedings or to lower the authority of a court or scandalize a judge in relation to his office or to disturb the order or decorum of the court is said to commit contempt of court.